Good morning, good afternoon, good evening, and welcome to AI for Good. My name is Wojciech of the ITU, the International Telecommunication Union, and it is my privilege to introduce today's session, Trustworthy AI Through Law, Current Proposals to Regulate Artificial Intelligence, by Djeffal, Assistant Professor at the Technical University of Munich. As part of the Trustworthy AI series hosted by Wojciech Samek, head of the AI department at Fraunhofer Heinrich Hertz Institute. ITU is the United Nations Specialized Agency for Information and Communication Technology, and is also the organizer of AI for Good, together with 38 UN sister agencies, ACM, and co-convened with Switzerland. For today's session, we'll be using the Q&A functionality to create an engaging discussion. With that, we're counting on your active participation. So please, any questions, post them in the Q&A, which you can find at the center bottom of your screen. Additionally, there is a chat functionality, which you can use to communicate with other participants. Please make sure that you send your message to all panelists and attendees so that everybody can see your message. And with that, it's now time for me to hand it over to our host, Wojciech. Show's yours.
Yeah, thank you. I'm very happy to introduce Christian Djeffal for today's speaker. Christian is an assistant professor for law, science, and technology at the Technical University of Munich. He researches and lectures on the relationship between law and technology, in particular focusing on new technologies such as AI or IoT at the Munich Center for Technology in Society and the TUM School of Governments. He is permanent visiting scholar at the Institute for Technology, Society and Law at the University of Zurich, and a real expert in explaining legal things to non-legal people. So I very much look forward to your talk, Christian.
Well, thank you so much, Wojciech, and warm welcome to everybody. It's a great pleasure for me to present in this prestigious series, I might say. And it's a pleasure to share part of my research with you, Trustworthy AI Through Law, because I think it's amazing that so many different scholars from different disciplines at the moment study the very same thing. So how can we create systems that are trustworthy, that we can actually use in society? And I look on this on a legal lens, but I'm always thankful for feedback and inputs from others. So let me briefly introduce. I have a research group, of course. It's not only my research and the work we do. Wojciech mentioned this already, is to look into emerging technologies in different areas of society, including legal tech, public communication, public administration, and public health. And we really want to take this design perspective and understand how can we bring different worlds together. And that at the moment, that's particularly topical. And that's what I will come to in a minute. Because I think there is a tension in trustworthy AI, and that's the first step actually of my presentation for you. So trustworthy AI is not like a thing we can discover, but it's an active process to get there. And one aspect of that, I think, is to understand regulation and the role that laws can play into it. Of course, technology is important, ethics, so social impacts, everything is important, but the law plays a unique role, and we see this at this very moment. So this week, things happened that I will introduce to you. And after introducing how regulation actually works in broad brushes, I would like to speak about regulation and trust. So what the relationship here is, in order to draw some preliminary conclusions, some lessons. So thanks for joining the ride for the next, I think, 38 minutes. And I start out with this first point, tension in trust, the tension in trustworthy AI. So basically, and I think this is not only applying to trustworthy AI, basically these kinds of concepts are defined and are understood by different people. So it's a normative aspiration to create something like trustworthy AI for some. For some, it's just a benchmark to say, I want to meet this, and then it's okay. So I think depending on from which perspective you look at it, it's really trustworthy AI can mean different things. And if you really force people to come up with specific solutions, you understand that at the moment it's rather an agreement to disagree. Yeah, we in a way have this goal to create it, but what does it actually mean? And this is not only the case for trustworthy AI. With phrases like sustainable development, it was basically the same. It started out in the 1970s, and some said, hey, we want development, especially the states from the global south, we want to catch up. And another strand of this discourse said, hey, in further development, we need to be sustainable in social matters, in environmental matters, in economic matters. So this was also a kind of common goal, including attention. And I think this is also true for trustworthy AI. And you can really see that if you look at the current materials, because we have ethics guidelines. One NGO counted 173 ethics guidelines. So it wasn't enough to have 10 projects, yeah, but a lot of projects which have some commonalities, but also a lot of differences, different foci, different things they stress, and so on and so forth. So you see this in the ethical discourse around AI, and you see it in the now over 700 AI policies of 60 countries, many AI strategies. Yeah, you see that there's a difference. States and international organizations emphasize different aspects of developing AI. So these processes run now for, I think, around about 5 years. I think 5 years ago, the first AI strategy was focused solely on AI, was published in Canada. So these processes run, but now we have really another wave of AI governance. And this relates to regulation. The question is, why is it so difficult? So why is it so difficult, and why is there so much material? Here, just to say that I would like just to say that AI is a general purpose technology. So it can be applied in different sectors, from health to the military and many, many other sectors. Different applications can be fueled by AI. And of course, also different stakeholders play a role. And this brings with it these different interpretations of trustworthy AI. So I think this is one of the reasons why we have witnessed just in this year and last year, a really rising tide of regulatory projects that have started out. So we see proposals either being introduced or being foreshadowed. And I would like to give you some examples of that. So the first example, many of you might be aware, is the European Union Artificial Intelligence Act. The new European Commission in 2019 made this one of their top priorities to regulate AI. And indeed, on 14 June, after a public consultation, the Commission actually published a proposal to regulate AI, an overall regulation, very interesting for the whole of AI. And this is just as we speak, is very hotly debated in the European Council, but also in the European Parliament. There are important decisions to make. So this is one example. The other example is in a little bit of an earlier stage, but the top advisors to the US president have written an article, and they propose a bill of rights for artificial intelligence and digitization, but specifically for artificial intelligence. And what they say is we have to have this bill of rights in order, in a first step, to enumerate the principles, but then also to guide public administration and policymakers in the US, and also to see where we need new laws. So this is really foreshadowing regulation also in the US, which many people didn't expect, but I think it's a strong voice and potentially initiatives will follow this. A little bit farther is a specific regulation of recommendation algorithms in China. The cyberspace administration released a draft in August. And this aims to standardize Internet Information Service algorithm recommendation activities in order then to safeguard national security, social public interest, and so on and so forth. So you see also a big, huge project of regulating at least a part of AI in China. And to make the picture more complete, also in September in Brazil, the Congress passed a bill creating a legal framework, which is still in the legislative process. But what's interesting is that this was a top priority from the Brazilian, Bolsonaro, the Brazilian president, and he sped up the process with his presidential powers. What this framework does, and I will come to the frameworks also later, is to lay out general principles for the development of AI and its regulation. And then this week also something happened because UNESCO gave a recommendation on the ethics of artificial intelligence. They released a 28-page document, which is not strictly binding, but the interesting thing is that all 193 member states agreed to this, and this shows initially a building consensus among the states, so it can have legal relevance. If so many states in the world agree on a document, this can have repercussions later on, while the language in this document is of course careful and stresses that it's not legally binding. So this was a quick tour d'horizon of certain developments we see at the moment, and this should give you the impression that we are really in the beginning of a growing wave of AI regulation. So this is a new wave of governance, and that it will answer to the question of trustworthiness of AI as well. So many of these projects are very specifically focused on trustworthiness and the many values AI can be linked with. So I will, in the next step now, introduce you to some very broad ways on how to understand these legal instruments and how to categorize them in broad brushes. So if you compare regulatory approaches, the one interesting thing is the level. So what is the territorial range? To what does it apply territorially? The second question is the generality. So the material range, to which situations or applications does it relate? And the third aspect is the regulatory approach. So how do we regulate? And this is just as a small introduction, so we are all on the same page. So let's look at the levels and generality. So regarding the levels, of course, you can have international documents like UNESCO, regional like the EU, national like the Brazilian or Chinese law, or subnational, part of a country. US communities, for example, have outlawed or regulated facial recognition. So local bodies in the US, cities, local councils have regulated also. And you can see there are different levels. Normally, regulation applies to the territory, but there can also be exceptionally extraterritorial effects of this regulation. The second is the generality of the regulation, and here it's important to know that there can be an overall regulation like we saw in the EU, but there's also a sectoral regulation where you say, for example, we regulate the health sector and all the technologies in the health sector. Or you can focus on specific applications of AI, like facial recognition or chatbots, and regulate them. And you could also look into what is an issue, so which human rights are an issue or are to be protected. And then you can regulate from this angle. This approach is, for example, used to protect children. So this should give you a broad overview, and we will categorize some of the approaches later. But now broad brushes on the regulatory approach. And I would also like to distinguish 4 regulatory approaches. And the first is principle-based. So just to give some abstract principles that can guide the practice and be the basis of further regulation. The second one is co-regulation. ITU is very important for co-regulation because here legislation provides a framework, and this has to be filled by other actors. And ITU has been very successful to provide for many standards by bringing together different experts. I think Wojciech is part of many of these projects. So regulation here puts in a framework, and this framework has to be filled by other actors, and this is co-regulation. The third one is a proper regulation, so really shaping behavior, the legislation telling you what to do. And the fourth one is the hardest and harshest one, it's prohibition. So outlawing certain forms of behavior. That's also possible, to completely outlaw certain forms of behavior. And in order to see how this works in practice, let's go back to the Artificial Intelligence Act, which is a regional overall regulation, but combines many of the ways to regulate artificial intelligence. And here it has principles throughout the whole proposal. So there is not one section or article outlining the principles, but they're mentioned throughout the proposal, so they're not in a way codified. It also has interesting aspects of co-regulation, like a code of conduct for providers who actually, to whom the proposal actually doesn't apply. So this becomes clear when I tell you about the regulation. This Artificial Intelligence Act specifically applies to providers of high-risk systems, and also has some transparency obligations for other systems. So this is the main part of the regulation. It's focused on high-risk systems. But there is a co-regulation. Even if you don't have a high-risk system, you can in a way create your standards according to the rules of high-risk systems, and in a way participate in the regulatory framework. But this is only the case if the actors actually engage in standard setting. And in what you also find in the AI Act is a prohibition of certain uses, like biometric mass surveillance, harm through manipulation, or social scoring. So these are in the proposal outlawed practices. So you see the EU actually uses all regulatory approaches to come up with a general framework for governing artificial intelligence. China is specifically focusing on some part and regulates this part. Just to bring you here some examples, they say they put regulations on algorithmic recommendation service providers and say they should fulfill their responsibility towards algorithmic security. And then they actually mention a lot of measures. Yeah, so this is what regulation does. They mention what they have to do, establish and complete management systems for user registration, information dissemination, examination and verification, algorithmic mechanism examination and verification, security assessment and monitoring, and so on. Yeah, so a lot of burdens or a lot of rules, obligations for providers of recommendation services. If you look for a purely principled approach, look to the Brazilian framework. Here, it's a kind of own translation I use. So it's to be handled carefully, but I think that the gist comes out of that. It gives you principles like beneficial purpose, shall seek beneficial results for humanity. It doesn't really say what this actually means, how it is to be implemented, but just states this abstract principle. And then there are further ways of implementation. So I hope that the preceding section gave you a kind of understanding how regulation more or less works, that you have different forms to regulate and different actors who actually do that. There would be a lot of things to say, but I think this is enough in order for us to try to tackle the next topic, which is regulation and trust. Regulation and trust is particularly interesting because one stream of legal philosophy really stressed the role that law can play in creating trust. And this stream was interestingly influenced by cybernetics. It's legal systems theory, and I give you here one of the leading proponents, Niklas Luhmann. And he said legal systems are actually communicative tools to stabilize expectations. So legal systems communicate whether behavior is legal or non-legal. And in communicating that, I can in a way pre-plan and know how people will behave. So basically, systems theory puts this trust-enhancing function of law as one of its most important components. Yeah, because through the law, I can really pre-plan my life because I know what is acceptable in society and what is not. So, but only if it's communicated in a clear manner. So you could say it's trust through law. Yeah. So in a way, the law specifies, the law in a way guides behavior, and you can really know what will happen. And I would like to follow this idea and now try to ask, what can the law? How can the law actually create this trust? How does this work in practice? And I would like to give you 4 points, 4 ideas of this relationship: specificity, speed, actors, and agency. And this should tell you something about the interlaces of law and trust and what it could mean for the regulation of artificial intelligence. So let's jump into the first question of specificity. And here, the interesting thing is that legal regulation requires a very high level of concreteness. This allows citizens to know rather exactly, or to know what to expect in a specific situation. And I think this is also the question, or the aspect why in specific situations it's so hard to agree on these laws, because you have to go down to the specifics. You have to get very concrete in order to negotiate that. And then people, of course, start to argue because you cannot just agree on umbrella terms. Let me give you an example about the specificity. So as you know, transparency is one of the interesting and major problems of trustworthy AI. So it's a big field of research. And when you look, for example, at ethical frameworks, they define transparency, they engage in this. But if you analyze the growing legal governance of transparency, you see how it gets more and more specific, and how transparency, the whole range of transparency, is in a way important in order to govern different situations. So I would like to give you an example of another proposal, the Digital Services Act. And this focuses on online services and mostly recommender systems, which are also fueled by artificial intelligence. And I would like to show you how what a nuanced transparency regime there is. So in Article 13, you find very general obligations for providers of intermediary services. So services connecting people delivering a service and people receiving the service. So Article 13 basically says you need to do a yearly report on content moderation, the measures, the availability, visibility, and accessibility of information, which is a broad measure of transparency. But if you go to Article 23, which talks about online platforms, so content moderation, this now gets narrowed down in subsection C. It addresses automatic means for the purposes of content moderation and requires the specification of precise purposes, indicators of the accuracy of the automated means in fulfilling those purposes, and any safeguards applied. Yeah, you see here we have a more defined measure of transparency. But this can also be varied in the way it has to be presented. So those two articles apply to reports. Article 24 concerning online advertising says, for each specific advertisement, there has to be displayed meaningful information about the main parameters to determine the recipient to whom the advertisement is displayed. Yeah, so here we have to communicate it on the spot, not only in the report, but on the spot. And in Article 29, which applies only to large online platforms, it says that they have to state, even in their terms terms and conditions, the main parameters used in their recommender systems. So you have to communicate the main parameters. And what I wanted to show you here is the way how even how in one regulation, yeah, you have a very nuanced and specific way of describing what's necessary to, in a way, be transparent in different situations. And the law really forces you to be that specific. Another area of specificity, and this is also the danger, is the very definition of AI. And as we speak, there is a fight about how to define AI for the Act of the European Union. The member states want to narrow the definition. Parliament wants to have it broad. And you don't need to read the whole Article 3, but be just aware that at the moment it's pretty broad, because software that is developed with one or more techniques is fairly broad. And then in Annex 1, you have statistical approaches, which would cover many approaches. So search and optimization methods. At the moment, many pieces of software would be included, which we wouldn't consider or think about as AI. Yeah, so this specificity also forces you to be precise, and there can be many arguments, which is why at the moment we have a lot of discussions concerning the very definition of AI, many more discussions, for example, than we had in the strategy concerning AI. Yeah, so but this specificity can create trust. And the second point is speed. And you might think, hey, why speed? Basically, regulation is so, the law is always lagging behind. And actually, what does the law have to do with speed? Has to do a lot with speed, because the regulation can influence the speed of innovation and adoption of technologies. While it has the ability to slow the process down, it can also speed up developments. And speed is specifically important in relation to trust. Yeah, coming from Germany, I have to tell you that the adoption of technologies like vaccines definitely depends on the trust, and the law is a crucial factor. Yeah, many countries like Austria now implement legislation with a duty to get vaccinated. So this is just one small metaphor or idea how legislation actually can influence the speed and the uptake of a technology. But let me give you first a slowing down example. This is a German law, and it says that it's about automated administrative act. And it says that administrative acts, so legal acts to an individual, can only be automated if it's permitted by law. Yeah, and German administrators call this the anti-e-government, so anti-digitization law, because it slows the process down substantially. Before you have any automated system, you would first need a law. So this takes ages, yeah, and many attempts to have these laws also fail. But it's really also meant to slow the process down in order to be sure before taking an automated decision. The problem for many administrators is that some automated simple process automations also for benefits for people, gets slowed down as well. So, but this regulation really shows you how to slow down things. The interesting thing, I think, is how to speed up the developments. And let me give you just 3 examples of how this can actually work. So the first thing is standard setting. Because in technology adoption and development, often it's very important to have common standards, and ITU actually engages in standardization in the space with the World Health Organization. The same does do medical device laws, which in a way engage and support standardization efforts. And once you have standards, it's much easier to build on these and to collaborate, or for example, small providers to come in. Yeah, so this can also stifle innovation. Once you have standards and know how things work, how data are to be collected and so on and so forth, this can really stifle innovation. And the law has this function to further standardization. Sometimes a regulation is needed to deregulate. So when the law itself has put up burdens, like the Vienna Convention on road traffic, which hindered automated driving. So you needed another regulation to change that. Another space is sandboxing. So to say, to create free spaces, experimental spaces by law in order to speed up certain innovations. And for example, the AI Act, the proposed AI Act, tries to do this in Articles 53. So the law can also accelerate developments. This is the takeaway from this second session or second point. And I'll jump right to the third point, which is about actors. And I think here it's important that the trust is in a way engaged by giving a more complete picture of the development. So the law is very multifaceted. With speed, I think the point was that sometimes it takes time to build trust, and the law can in a way slow down the processes. But sometimes it's also important to be quick and just to help people to accept the technology so they can get used to it and actually accept it. But then it's also important to have a full picture of society and to in a way know about the different positions. And I would like to go back to the AI Act to show you how nuanced the law also is in that regard. So on the one hand, it looks at the providers of AI technologies. So those who actually develop it, could be an organization or a developer. But it also includes importers and distributors. So people in the value chain. Yeah. So because also they can have a responsibility and they can have an influence. So it's important in order to build trust, not only to look at the developers on the ground, but to have like the whole chain of, for example, commercializing AI, and to in a way also distribute responsibilities, so people can trust, because it's not only the developer whom they never saw, whom they never interacted with, but for example also the distributor, the person or the organization who actually sold these items. Yeah? And interestingly, also the user comes into play. So also the user plays a role, and even the user can have certain obligations as other third parties. So this regulation is actually open for other actors to be also considered. So this is to show you that, and this is also typically for the law, that it really looks into the different roles actors can play and address them as such. And this has also a trust building function. And now for the last point, I would like to stress agency. Laws and the law itself can enhance agency on different levels, and this can increase trust. So it can help you to act It can help you, or it tells you that you can become active and people are becoming active on your part. So it's not only an obligation in developing AI, but also if something goes wrong, or if you want to know, you have actionable tools to become active and to follow up on trustworthy AI, to really question, to become active. And let me outline 3 mechanisms of how this works. So the first point, and this is really important, is the rulemaking, because it's very important that this rulemaking is democratic and many stakeholders have possibilities of influencing processes and actually making these laws. Yeah, it's a long-standing critique that it's very problematic for expert and technocratic organizations to be the only ones to determine rules on how to assess technology. And I think this rulemaking aspect gives you the opportunity to legitimize the rules, while this co-regulation still allows for expert opinions and standards to come in. So I think this is a first part of agency, because policymakers are actively engaged in regulating, and they have to get down to the issues, and they have to, in a way, become familiar with topics so that they can basically regulate. And this increases trust, because you have now a completely different stakeholder and party of policymakers coming in. The other thing I would like to stress is subjective rights. So in many of the regulations I showed you, there are not only obligations on developers, but actually you have subjective rights that can be enforced. So you can go to court and, for example, enforce the rule on personal advertising I showed you. So this is another aspect where law can increase the trust, because you have an actionable way to actually enforce the rights you have. And the third part is enforcement itself. So this is also something that the EU struggles about, or where there are differing opinions how far the enforcement should go. At the moment, there are enforcement measures planned that would go up to 6% of the yearly turnover for single violations of the AI Act. So I think that's very interesting and telling that it's really 6% of the yearly turnover, which will definitely enhance compliance, but also creates trust, because the companies cannot just disregard this standard, but they actually will incur substantive losses. And the same is true, for example, for punitive damages, so high damages in the US system. This really makes companies rethink their decisions, and other players rethink their decisions, and shows how this level of agency in a way helps to increase trust. So I hope that you took something away from the 4 points I showed you, and I explained different aspects in the meantime. And I would now come to preliminary lessons that could be drawn from my talk. And the first one is that a trustworthy AI is not like this single ideal solution, but a result of a bargaining process. It's a process of in science developing new things and understanding new things, but also coming up with standards that we want to meet and that we want to agree on. And the law is really an important tool to help define that, because it can stabilize expectations. So it can tell people what to expect if it's done correctly, with all the problems and intricacies this can have. But a good regulation can stabilize expectations in technologies and applications. So it can actually help fulfilling this promise of trustworthy AI. And one aspect is its specificity, because it really can get down to very specific situations and a nuanced governance, but also control the tempo of innovation and adoption. Yeah, we always say the law lags behind, but actually it can control the tempo. And it can also take into account a multitude of actors who are relevant. That's really good to have a more complete picture also of the actors that can actually influence these processes. And it furthers control and agency, yeah, to really give, in a way, teeth to trustworthy AI and to really show, okay, there are actionable ways to influence the rules and to influence how we shape our future by shaping AI. And I hope that this presented to you some general ideas about law and regulation, but also some new developments in the regulation of artificial intelligence. And I thank you very much for your attention. I'm really looking forward now to your questions.
Yeah, thank you, Christian. It was a very interesting talk. So I learned really a lot. So we have some questions in the Q&A. So I will maybe start with one. So do you see the effort of CAHI, of Council of Europe, as on category of regulatory approaches?
Yes, I think for the Council of Europe's efforts, it's at the moment quite early to categorize it, but I think that they will, it will have regulatory elements, and I think it will end up as a kind of, so the Council of Europe is an international organization that has built very important and successful frameworks for cyber governance, like the Budapest Convention. I think this will be kind of a basic framework comparable to Convention 108, which is a kind of basic data protection treaty that states can join, and they can adhere to it and build their own data protection regimes. So my best guess is that it will go this way, that you have a kind of common denominator and minimum standard, which will include some regulatory elements, but not be a complete regulatory framework. So that's my observation on the process. I can also share the links. They're really in the middle of discussing it. But thank you very much for the question, because I couldn't include the Council of Europe in my slides without violating my time restriction.
Here's another one, quite interesting. So why the regulatory framework is limited only to the use of AI, but not extended to AI-related innovation? Or is it a contradiction, or can we also like extend such framework to things which are invented by the use of AI? Or
I think that's a very good question, and to be honest, I haven't thought about it, because the AI innovation that I read about most are things like music, films, and books. I think with music, they're pretty far. There are even some AI songs in the charts. But I think the areas that I know about are typically areas which are not like directly regulated, because there is not a lot of danger from music. You could expand on this, whether music can be dangerous, but so far the inventions I know didn't really go into regulated areas. But one area where this could be relevant fairly soon is actually cybersecurity, because AI has now capabilities of breaking into systems. And at the big hacker events, I think AI is now competitive. So AI systems didn't win these events, but were somewhere in the ranks. And I think if this trend, in a way is furthered, we will have exactly your question. So how do we regulate from a cybersecurity perspective AI that detects loopholes and in a way can attack systems? And this could be something that will be regulated. So I think we, as you said, we need to be careful and see what AI is able to bring out, what kind of inventions. And I could see some regulation, for example, in the field of cybersecurity.
Here is another one about like the costs for the European Union, which are through the regulation are estimated at 31 billion euro over the next 5 years. So can this process drive away investments in Europe to other countries where maybe things are not so much regulated?
That is possible, but on the other hand, I think it's a kind of mixed calculation. We had the same argument with GDPR, the General Data Protection Regulation, and when this was negotiated, everybody said, well, once we have it, it will drive out any data economy out of Europe. But actually, exactly the opposite happened, because the European Union is such an important economic bloc that to some extent, these standards in a way proliferate to other parts of the world if they are well done. Yeah, and I think that's the more important question. I think this money is well invested in the case that it's not only bureaucracy, but it helps us to actually achieve trustworthy AI. And if this is the case, if the standards work, then Europe as a market will require this. So others will also have the same implementation costs. And I think also if you innovate, it's good to know about societal expectations at a rather early age. Yeah. So I would like to question whether, because this is really the thinking of the internet economy, move fast and break things. And I think this idea of scaling really works in the internet economy. But if you build, for example, a medical device, yeah, and you move fast and break things, then it can harm your reputation. It can lead to real world damages and also push you out of business. So I would say if the regulation is well done, this will be money well invested because it's also a competitive advantage, specifically in high risk areas, to have trustworthy and reliable systems. And to have this reputation, but of course it's an important effect. I definitely agree. Yeah, it's implementation costs, and this has to be justified by a good regulation that really helps you to achieve a trustworthy AI.
Maybe one comment to the attendees. So we can only consider questions which are posted to the Q&A. So please do not post your questions to the chat, but rather use the Q&A functionality. Yes, another one. So how does intellectual property of AI system affect regulation speed? Would you regard AI be easier if all were open source? Would the regulation be easier? How do patents and intellectual property affect the regulation?
I think this is an interesting and difficult question. On the one hand, if you make AI innovations, it's important to incentivize this and also give some form of credit and incentive for people to actually do this. So this would speak in favor of finding ways to protect intellectual property in the case of AI innovation. On the other hand, we have a kind of, on the one hand, there is a lot of important innovations from science who are more open by design. and also the big players, I think, have a big interest in being open, because by being open, they can also determine the standards. Yeah, whoever in a way manages to build important components that might be considered part of the operating system of the AI ecosystem will have substantial influence. Yeah? So I think this is another aspect to be open. So I think there are many many aspects to this, and I focused today more on the technical regulation. I think the development of intellectual property law is another important issue, and here the deciding question is always, how do we stifle innovation? Yeah, so really help people to innovate, so that also have something if they had a nice invention. And the idea of intellectual property law is also that you get something, but you also make your innovation available. So intellectual property law also helps you to publish, for example, patents. You publish it, and after 15 years, it's for the world to know and for the world to use. And within these 15 years, people can use it if they pay fees. Yeah, so I think also within intellectual property law, there is a kind of this mechanism to avoid secrets, yeah, so that everybody can participate in the knowledge. And one would have to find the right balance for AI innovation, indeed.
Here is a question regarding themes like explainability of AI. So it's kind of on the agenda of many standard settings organizations. But what do you think should be the role of private appropriations of this concept? For example, by including industry standards or essential standards patterns. So what is the role also of the industry in this process? So because this is also something which I often observe, that there is an essential gap between this high-level regulation standards and things and the implementation. So how can we overcome this gap?
Yeah, I told you that I think the regulation on the way is getting more and more specific, and it provides for frameworks to help, and this will, some of them being very determinative, some of them actually just inducing private standardization. So I think once we make very clear what the level of transparency should be, on the one hand, it's it's easier for stakeholders who actually have the technical knowledge to do that. But I think one thing that goes with that is that we have, especially for the topic of transparency, we have to open the process of standardization and bring different stakeholders in, from civil society, from and also, so what we experiment with is deliberations, working with random samples of the population and educating them. And in the beginning, I was very skeptical, but I think it's wonderful what insights you get if you discuss this with samples of the population, and really in cases where they can really have a say. So if I think about an application that's like medtech or general recommender systems that are used by large parts of the population, it might be very interesting to look also for these democratic avenues, because whom do we do the transparency for? Yeah, if it's transparency for the people, then it would be good to find ways for specific questions to include the people. Yeah, and if it's more of a technical problem, for example, transparency for a doctor or for a mechanical expert, yeah, I think then we are that's a topic for industry, and then industry really needs guidance. And I hope this example from DSA shows you that the law actually helps to work towards being more and more specific. Yeah? And the AI Act, for example, will also include standardization on the commission, so to have guidelines from policy experts and to induce these processes as well, which also complement industry standards in that regard.
Mm-hmm. So in general, how can we ensure like that civil society organizations play a bigger role in this process, in this AI regulation process? Are they playing a role, and or how can we help them to play a bigger role?
Yeah, I think, to be honest, they play a crucial role. They play a crucial role if you look into the consultation processes, into the public pressure that was exerted, for example, for prohibitions, but also for in other questions like now concerning the definition of AI. I think civil society already plays a big role. And I think to the example I just gave, so standardization processes, to maybe to open this up to a certain extent for civil society might also be a good good point, because there is a lot of expertise in civil society. Many people to mention, but the Chaos Computer Club, for example, is asked in many instances. So I think there are already avenues, and maybe if this is formalized to a certain extent, more in the process of standardization, this might be another track to achieve that.
Here's another very interesting question regarding responsibility. So when something goes wrong, when, for example, Alexa opens the door unexpectedly and allows a burglar to enter the house, who is responsible? So the user who signs up of using the product, the company who sells the product, or the developers who design and implemented the algorithm, or someone else?
So I think that's a very interesting question. The interesting question is how is it different from a key and a lock? Yeah. If I have a key in the lock, I know that I can call the key service, and the key service has some way to get in. So I know that there is no perfect security with a normal lock, and there will be no perfect security with Alexa. But we need to find, and this is in the law, this is often done by jurisprudence, we need to find the right measure of what I can reasonably expect from this lock, and for example from facial recognition. So if the burglar just gave a photograph of me in two-dimensional photograph, this will not be enough. Then I say, okay, this is not the state of the art. So this would be one legal tool to determine this. Has the company applied the state of the art? And this includes everything that is foreseeable. And all the measures the companies could reasonably take. Yeah? And so we would need to get down to the facts of the case, but the state of the art and the proportionality of the measures play a big role. And what I would like to stress here is that regarding AI, AI will never be perfect, but also we don't live in a perfect world now. Yeah, so my my house is only so and so protected, and also with AI there will be a certain level of protection. So one other question would be, is the protection overall a little bit higher, or at least comparable to what we've seen before? I think these kind of social technical comparisons should be very important in the future. Yeah? That we don't only look at the AI, but also at reality.
Mm-hmm. And those measures and metrics, so will there be like application dependent, or can we also think about some more generic KPIs of measures which kind of you think should be fulfilled in order to sell the system, or to make the system ready and call it a trustworthy AI?
Yeah, I mean, Wojciech, you're an expert in health tech, yeah, and in health tech we have clinical trials, and we know with these clinical trials that there are some. For this would be an example where there are some measures, and I know that a certain within a certain percentage, a medical product is acceptable, and when it's not accurate enough, it would be not. So I would have to go into the specific standards for specific applications to give you the exact numbers. But I think we have that already. So and the law can give like a general overview of these measures, or at least also show you how to balance that out. Yeah. Because the problem with the KPIs is not only what happens if it goes ill, but the other thing is what does this device also bring to us? How does it improve the life of many others? So if there is no death involved, this can be somehow outbalanced if I have a device that crashes from time to time, but it brings a lot of value to many people. This can be then acceptable. And in some parts of the legal regulation, the law also describes how to balance that out. Yeah, so one institution is the principle of proportionality. So this is one technique to do this in public law, and I think it's also good to have an accepted procedure on how to balance certain values.
So I have a last question. So where are we in 5 years? Are we still discussing about AI regulation, trustworthy AI, or are we done with it? Do we have something which is acceptable, which we are happy with, which, like, yeah? So what do you think?
You know, as a lawyer, I think I don't believe in, as I said, with trustworthy AI in some perfect state. I think it will be a constant struggle, but I hope that we are farther along the road. And I think we will have in some jurisdictions regulation on AI. And I would love to interview you now, Wojciech, at that time, to see whether you think that they make sense or how we can further improve them. Yeah. So because I think we are just at the beginning of understanding AI-induced innovations and the many things we can do. Yeah. I really like this question of, hey, what's happening with the things that AI can do or AI can innovate? Yeah, I think that's a wonderful question, because I think also there will be new questions and things we just see along the way. So I hope that we will have a good framework that helps us deal with the most important problems. And I hope that we're still in contact also with participants in order to discuss how we can improve this framework.
Yeah, thank you, Christian. It was an excellent talk and a very fruitful discussion. So thank you again for being here today.
Yes, thank you, everybody, and have a nice morning, evening, or afternoon.
Thank you, Wojciech, and a big thanks also to our speaker, Christian Djeffal. We hope you enjoyed the seminar today, and we're launching a quick poll for you to say so. It has helpful smiley faces for you to understand what the answers mean. In the meantime, let me mention a few things that may be of interest to you. On Tuesday, together with Fondation Botnar, we are hosting a hybrid event, so part physical in Geneva and part online, the case for digital health, accelerating progress to achieve the universal health coverage. This is part of the Digital Health Week, which is held at the same time as the special session of the World Health Assembly. And then next Thursday at 3 p.m. European time, we have our next Trustworthy AI webinar, Algorithmic Recourse from Theory to Practice, with Isabel Valera, Professor of Machine Learning at Saarland University. You can find more information on this and the links to the event pages where you can register in the chat. Also, a link to the AI for Good website in the chat. Please have a look, aiforgood.itu.int. And with this, we have reached the end of our webinar today. I would like to once again thank everyone involved. So first of all, our speaker, Christian Djeffal, our host, Wojciech Samek, you, our participants, our partners, sponsors, and the co-convener, Switzerland. And we hope to see you all soon.
selector, rewind selector, rewind selector. Rewind selector, rewind selector, rewind selector. Selector, rewind selector, rewind selector.